Today's video is meant to touch on a racial issue that thrived between two successful soda brands. Despite having similar colors, ingredients, and even related history, these two brands had a downswing of racial rivalry. Let's dive into this, guys, shall we? Firstly, we'd be looking at the racial issue between these two drinks, and furthermore the history of Pepsi. A link to the history of Coca-Cola is in the video's description. Go check it out too. It's very insightful. So what brought about this racial issue in the first place? First and foremost, the truth about the history of America's favorite soft drinks, Coca-Cola and Pepsi, may shock you. Coca-Cola, marketed prominently to white people. Throughout the 1920s and 1930s, the company, studiously and purposely ignored the African American market. Pepsi, on the other hand, started out by primarily targeting African American consumers. In fact, during the 1940s, the company launched a negro markets department and even had black sales representatives working hard to promote the brand in urban areas. They also aggressively hired black models to appear in Pepsi ads that were featured in black publications. Special point-of-purchase displays also appeared in stores that were mostly patronized by African Americans. Neither company, Coca-Cola or Pepsi, had an inclusive marketing strategy in the beginning to promote their soft drinks to people of all ethnic backgrounds. In fact, they were avidly known as white and black drinks for quite some time. In later years, however, both companies did eventually begin to implement diversity advertising campaigns after realizing that they were missing out on the opportunity to generate billions of dollars in revenue. But that didn't put an end to the racism. In the year 2000, for example, Coca-Cola was ordered to pay $156 million to settle a federal lawsuit brought by a group of black employees who accused the company of racial discrimination. Pepsi was forced to do the same in 2012 when they paid $3.13 million to settle a federal lawsuit stemmed by accusations of racial discrimination for using criminal background checks to screen out job applicants who were arrested but not convicted, disproportionately excluding black people. Let's get more insightful and take a closer look at the lawsuit Coca-Cola was involved in. In 1999, a class action lawsuit was filed by current and former African American employees against Coca-Cola in the U.S. The plaintiffs alleged racial discrimination which resulted in lower pay, less promotions, and poor performance evaluations. In 2000, Coca-Cola agreed to the largest settlement ever in a corporate racial discrimination case in history. Cyrus Mary, an American attorney, served as co-lead counsel in a suit against the Coca-Cola Company representing four named plaintiffs and a class of 2,200 current and former salaried African American employees. The suit, which alleged that Coca-Cola employed racially discriminatory business practices that limited the professional advancement of African American employees. Among a long list of allegedly inequitable business practices, the plaintiffs alleged a substantial difference in pay between African American and white employees, a glass ceiling that kept African Americans from advancing past entry-level management positions, glass walls that channeled African Americans to management in areas like human resources and away from power centers such as marketing and finance, and that senior management had knowledge of these inequities since 1995 and failed to implement policies to remedy them. In the settlement agreement, Coca-Cola denied the allegations, but agreed to make sweeping changes to its personnel policies and procedures. In addition, the settlement gave an outside panel, jointly selected by Coca-Cola and the plaintiffs' lawyers and approved by the court, limited authority to revise the company's personnel policy. This panel, the task force, served as a watchdog for 5 years and was charged with evaluating Coca-Cola's compliance with the terms of the settlement agreement. The task force issued its final report in December 2006, finding that its mission has been a success and that the company had made significant progress. The monetary settlement in this case was in the amount of $192 million. The majority of this money went to repay employees for lost earnings and non-wage related damages. Damages to any individual class member were capped at either $150,000 or 3 times the individual's salary as of December 31, 1999. Additional money was paid to the class representatives who brought the case to compensate them for their efforts. To make things clearer, in fact, in addition to the monetary relief, the settlement required that Coca-Cola become a leader among Fortune 500 companies in equitable employment practices. In 2004, Luke Visconti, a co-founder of Diversity Inc., which rates companies on their diversity efforts, said, "Because of the settlement decree, Coca-Cola was forced to put in management practices that have put the company in the top 10 for diversity." Programmatic relief. The settlement mandated that Coca-Cola overhaul its performance evaluation procedures on the advice of industrial psychologists, improving on the largely subjective process that previously existed. Additionally, these annual performance reviews now contain an explicit right to appeal for anyone who believes their review was unfair or inaccurate. Coca-Cola agreed to implement changes to the manner in which staffing and promotion decisions were made, broadly publicizing openings to ensure that all interested candidates became aware of opportunities. Coca-Cola also agreed to ensure that a slate of candidates for any upper-level position would include female and racial minority candidates for consideration, with the company retaining the right to actually promote whoever it deemed most qualified after considering a broader range of applicants. The settlement also empowered a task force with broad authority to supervise progress and suggest changes to company hiring, employee evaluation, and promotions practices. The recommendations of the task force were significant, and Coca-Cola was mandated to follow them or to obtain a court injunction releasing them of this duty. The task force was responsible for generating yearly reports assessing the progress made by Coca-Cola in attaining a more equitable work environment for racial minorities. The task force released 5 of these annual reports, the last one being in 2006, and subsequently disbanded. We would discover later that all of this did change their course of action, but scandals still went on in their premises years later. In March 2012, 16 workers of color sued Coca-Cola, claiming they had to work in a cesspool of racial discrimination from 2 different production plants on the East Coast. All of the plaintiffs are either black or Hispanic. One plaintiff commented that she was looking forward to working for the company when she was first hired because of its reputation. However, she claims that after she was hired, she was subjected to numerous demeaning comments made by white workers at the plant. The lawsuit accuses the company of delegating less favorable job duties to minority workers. The lawsuit also claims that the company did not take appropriate actions when workers complained about the discrimination. Some plaintiffs claim that they experienced retaliation in the workplace for raising their concerns about the discrimination. "I thought this was a fair and honest company," one worker stated. Since the lawsuit was filed, Coca-Cola has issued a statement claiming that the company does not tolerate discrimination at its plants, and that it will investigate the workers' complaints of racial discrimination. When workers' complaints are not addressed properly by their employers, employees who believe that their rights have been violated in the workplace may be able to take legal action in order to hold their employers accountable for fostering hostile work environments. Another racial scandal did pop up again in the 2020s, this time not with people of color. In February 2021, recordings of an employee training course were leaked on social media. The course instructed employees to be less white, which the course equated with being less arrogant and oppressive. Coca-Cola responded with a statement in March 2021, both clarifying that the leaked documents were not an official part of their training curriculum and apologizing for the incident, claiming, "We would never encourage anyone to be any less of themselves." Meanwhile, the training session was in association with Robin DiAngelo, author of White Fragility, Why It's So Hard for White People to Talk About Racism, and was sent to staff to help build an inclusive workplace. DiAngelo has done diversity training for businesses for more than 20 years, and previously said she has experienced hostility from white people when talking about race during her training. Her White Fragility book discusses the response white people have when their skin tone is mentioned. She argues that wokeness also doesn't deal with the problem of race, as it helps to avoid questioning one's own unconscious racist bias. One slide in her training session sent to Coca-Cola employees outlined that to be less white is to be less arrogant, certain, and defensive. Another slide expressed the idea that in order to confront racism, you first have to understand what it means to be white. Please buckle, guys, because we still have a lot to unpack. Please, if you're enjoying this video, hit that like button and subscribe. Don't forget to comment your thoughts. Thank you. Research shows that by age 3 to 4, children understand that it is better to be white. Read another slide from DiAngelo's course presentation. Lawyer and Republican Party official Harmeet Dillon shared photos of the seminar on Twitter, commenting that the course includes blatant racial discrimination. Conservative commentator Candace Owens added, "If a corporate company sent around a training kit instructing black people how to be less black, the world would implode and lawsuits would follow." You guys agree with this perception? Please let me know your thoughts. In a statement to the Independent blog, the drinks giant said the seminar was not part of Coca-Cola's learning curriculum. Our Better Together global training is part of a learning plan to help build an inclusive workplace. It is comprised of a number of short vignettes, each a few minutes long. The brand said, "We will continue to listen to our employees and refine our learning programs as appropriate." Continued Coca-Cola's statement. The Confronting Racism course with Robin DiAngelo was publicly available on the employment site on LinkedIn until recently. It has since been removed. A representative for DiAngelo told The Independent, "The online training from LinkedIn Learning that was circulating was not a course by Dr. DiAngelo, but a series of interview clips that had been edited together without her knowledge and presented as an educational resource. She had no involvement in it being presented or marketed as a training session, did not approve its distribution, did not know it was being used in corporate settings, and because of that, it has been removed from the site and discontinued voluntarily by the groups that created and distributed it." In all of these racial scandals, Pepsi even got involved. Despite being promoters of their brand to the black community, they still found themselves in a racial scandal back in 2012. Case study: Racial discrimination at Pepsi. In 2012, Pepsi Beverages Company settled such a case with the Minneapolis office of the U.S. Equal Employment Opportunity Commission, EOC. Pepsi agreed to pay $3.13 million and provide job offers and training to 300 African American job applicants across the U.S. who applied for positions between 2006 and 2010. Prior to 2010, Pepsi had a policy of not hiring workers with arrest records. The policy denied employment to applicants who had been convicted of minor crimes and applicants who had been arrested but not convicted of crimes. The EOC found that the policy disproportionately excluded African American applicants from permanent employment with the company. The use of arrest and conviction records to deny employment can be illegal under Title VII of the Civil Rights Act of 1964 when it is not relevant for the job, because it can limit the employment opportunities of applicants or workers based on their race or ethnicity. As of today, no racial scandals and lawsuits have been publicized or presented by past and present employees from the two companies. Today we can see ads, marketing to all kinds of people from both corporations. Well, inclusivity and diversity does not seem to be a problem, and would have been incorporated in the work environment and adverts of the two corporations, at least from our research. Well, this concludes the video, guys. If you'd like to know the full history of Pepsi soda, please check out our recent uploads. See you soon. Bye!